Well, thanks everyone for joining us today to discuss the legal developments in child and teen protection. To give you a little bit of background about myself, my name is Lindsey Tonsager. I co-chair Covington's privacy and cybersecurity practice, and I have a robust public policy regulatory enforcement practice in the kids and teen space. What I'm hoping you'll take away from today's session are three key things. First of all is an understanding of what the most common triggers are for when the minor protection laws start to apply. Second, what the key legal requirements are across the different legal frameworks at issue. And third, to help you see around corners where the law might be headed in this space. So we'll begin with the different applicability thresholds. There are more than a dozen different laws just in the United States alone in this area. And so first, some of the laws get triggered depending on the particular age of the user. So I've included a number of different age threshold examples in this slide. Under the federal law, the Children's Online Privacy Protection Act, and some of the state laws like Virginia SB 361, the age threshold that's relevant are children under the age of 13 years old. However, that is by no means a uniform standard. Other laws, like portions of Florida HB 3, apply an under 14-year-old standard. Still, other laws, like the California Consumer Privacy Act and the Ohio Parental Notification Act, apply to minors under the age of 16 years old. A lot of the age-appropriate design codes, like that one in California, apply an under 18-year-old threshold. And you've got the Puerto Rico Protection of Cyber Protection Act, which applies an under 18-year-old threshold. Separate from those age thresholds, there's also triggers that depend on the type of audience that you're directed to, or whether or not you have knowledge about how old your particular user is. So I've included some of the standards on this next slide as an example. First are the buckets of laws that cover whether or not you're directed to a particular audience. So the law might get triggered if you are child directed, and there are variations of the child-directed standards. So for example, under the federal Children's Online Privacy Protection Act, different regulations apply if you are primarily child-directed compared to those child-directed services that are secondarily child-directed, where children are not the primary audience, but they are definitely an intended audience of that service. There are also laws that are triggered if your service or site is directed to minors. So that would be the laws that apply to not only children under 13, but also teenagers. And then these laws sometimes talk about differentiate directed to minors or directed to children from services that are directed to a general audience. Separate from those laws that focus on whether or not you're directed to a particular audience are laws that use a standard likely to be accessed by children or teens. So that really focuses on empirical evidence and other factors of who's likely to access or likely to visit your site or service. And then even separate from those audience triggers are the knowledge triggers. And that standard will look at, do you actually know, or should you know, the age of a particular user? So you have on one side of the spectrum constructive knowledge, kind of circumstantial evidence of age, whereas on the other end of the spectrum, you have actual knowledge requirements where you know with certainty the age of the user. The final set of triggers for determining which laws are going to apply to you are different types of service offering thresholds. So under these types of laws, it looks at whether or not you offer certain types of features or functionality as part of your service. So these include things like, do you offer public or semi-public profiles? Do you have a list of users that allow them to share social connections with one another? Similarly, although it uses different language, so it's a different standard, do you have functionality that allows users to create or post content that is viewable by others? Or do you recommend user-generated content based on user information or device level information from each particular user. Other laws use standards such as, do you employ algorithms to select content for each particular user? And then there's laws that apply to particular types of content or devices. So there's laws that only get triggered if you are offering content that constitutes pornography, or if you are a manufacturer of a device like a tablet or smartphone. And then finally, there's laws that have been proposed that would regulate chatbot functionality. So once you've kind of figured out across the different laws, what are the thresholds for triggering those legal requirements, and do you satisfy those many, many different thresholds? Then you get into the substance of the laws. What do those laws actually require? And obviously, there's a lot of different triggers, there's a lot of different requirements. Rather than go law by law by law, given that there's dozens of them, what I tried to do is combine in a pretty digestible way what are the common requirements across these different laws, so you have a sense of the type of issues that are on the minds of the regulators and the legislators. So the first key substantive requirement that we see across these various types of laws is age assurance. And again, there's a lot of different standards or triggers that can apply. So one flavor of law says if you don't offer any age assurance mechanisms, you have to assume that everybody on the service is a minor and apply all of the minor protections to all of your users. A different flavor of this, which is actually kind of approaches it from the opposite perspective, is that it's like a carrot. If you do conduct commercially reasonable age assurance, then if somebody lies about their age, you're not going to be liable if they've given you a falsified age. Other laws focus on the age assurance being the age that they tell you they are. So the federal COPPA law is a great example of self-declared age as being the standard age assurance. Other laws, though, require you to go beyond what the self-declared age is and encourage companies or require companies to estimate or predict what the user's age is. And some of these laws will kind of base the age estimation standard on what's a reasonable mechanism based on the level of risk associated with that particular site or service. A step beyond age estimation would be the age verification laws. So now you're not just predicting what is somebody's age. You're not just taking it at face value what they say is their self-declared age, but you're going a step further and you're actually verifying the age information that they provide to you. And there's different flavors of the age verification standards as well. Some laws require age verification to be based on the provision of a government ID, like a driver's license or a passport. Others focus on age verification based on biometric matches using a vendor. So this might be comparing the uploaded government ID with a selfie that's taken in real time to make sure there's a match. Some laws don't specify the mechanism by which you need to do age verification. They just say you can use a mechanism as long as it's determined to be meeting a certain accuracy threshold. So some of the laws will go as high as you need to use an accuracy threshold of up to 95% accurate age verification. And then another flavor of laws looks to third-party signals. Sometimes those third-party signals might use some of these verification or estimation mechanisms that are discussed in the other laws. Other times they talk about like a browser or device level signal without getting into a lot of specificity on what that might entail. So an example of this is the New York Child Data Protection Statute, which has an ongoing rulemaking right now where we're expecting to see regulations kind of clarifying what these age signals will look like. Another substantive requirement that kind of appears across many of these different laws is the concept of transparency, being clear with your users about how you're processing their personal information. And these notices, these transparency measures take a number of different forms. So one example is giving parents a direct notice explaining to the parent how you're going to process the minor's personal information. Other laws will also or separately require an online privacy statement. And sometimes that online privacy statement is focused on providing information to a parent. And in other contexts, like the age appropriate design code laws, it's focused on making sure that the online privacy policy is written in language that's understandable to the minor, including sometimes very young children. So it's kind of an understandability type concept. Other documents that are sometimes referenced in these transparency requirements are the terms of service and any community guidelines that regulate how users should interact with one another on the service. Consent is another very common theme across of these laws, and the type of consent required and when the period at which it's triggered often varies across these different laws. So some laws will require consent of the minor. So the state comprehensive privacy laws are a great example of this type of consent requirement, where often a teenager under certain age thresholds will need to provide opt-in consent before their personal information is used for, say, targeted advertising or selling or sharing of their information. Separate from the minor consent requirements is a whole slew of parental consent requirements. Sometimes the parental consent is triggered whenever you're processing the child or minor's personal information. Sometimes parental consent isn't required for personal information processing, but instead is triggered at the moment that an account is created. So they might be able to see or view content on the service, but once they actually take the step of registering for an account, that's when parental consent might be triggered. And then another flavor of this is they can create an account, but they need to get parental consent in order to enable specific functionality under that account, like being able to see certain types of information feeds, for example. In addition to these parental consent requirements, parents also commonly have a number of other rights under these laws. So one of which is access or deletion. So parents should be able to contact the company and request access to their minor child's personal information or request that it be deleted from the company's systems. There's also, under some state laws, an unpublished right. So even if you don't have to delete it, you have to remove it from public view, and a whole host of different supervision rights for parents. This might include things like being able to review the minor's privacy settings, account settings, how much screen time they're spending, when they can receive push notifications. So there's a lot of different flavors of the supervision requirement, and what exactly is required will vary from one law to the next. The next common theme across a number of these laws is what I'll refer to as well-being standards. And some laws define these or apply these as flat out prohibitions, and other laws will impose affirmative obligations on companies. So an example of the prohibitions is they tend to have a lot of variety in the triggers. So the knowledge standard for these prohibitions will vary from either the business has actual knowledge, they have reason to know, or they willfully disregard, depending on the law, that they are engaged in activity that's materially detrimental or poses some substantial harm. Again, that standard varies. To the minor's physical or mental health, some focus on well-being, and other laws focus on privacy. So you've got kind of the knowledge trigger varies law by law. The type of harm trigger varies law by law. And what the law is trying to prevent varies law by law. But regardless, across those different standards, it's a flat out prohibition on offering that activity to the minor. For those laws that have instead affirmative obligations, again, there's a lot of variety in the standard that applies. So some laws will say that companies have to use a reasonable care to avoid heightened risk of harm that might be caused by the service. Instead of reasonable care, other laws oppose a slightly different standard of commercially reasonable effort to prevent or mitigate exposure to harmful content. Others will not be so focused on what's the level of effort applied, but instead will say, well, you have to develop and implement a strategy. And that's actually the word used in the statute, a strategy to prevent exposure to harmful content. And then other laws that take this approach just say kind of generically, you have to take measures that are in the best interests of children. So there's a lot of variety across the law. Like even if the law has a similar affirmative obligation to do something to address well-being on the platform, there will be very different thresholds, very nuanced standards, law by law, to address that concern. The next set of substantive requirements that we see very commonly is this concept of building or designing the service or product for the child in a way that builds in or bakes in specific protections for the younger users. And I've listed the 9 most common protections that we see appearing across these different laws on the slide. One is just a generic, you have to apply high privacy settings by default. Not a lot of detail on what it means to have a high privacy setting, but the idea is generally if you have a setting, the default should be the high privacy one. Other laws get more granular about what this might mean in practice. So some laws focus on, is the account visible to other users? Are there limits on the types of content or the scope of sharing of their content across, with other users of the service? Some of the laws restrict the default information stream that is displayed to the younger user, that they're supposed to be more chronological in order rather than have that default feed be personalized for the particular user's consumption. Other laws focus on screen time limits, limits on when push notifications or in-app notifications can be displayed to the user, or kind of scheduled take a break notifications or requirements. Another common kind of product design restriction that we see is whether or not the profiles can be made available to search engines for indexing and searching through public search engines. Limits on precise geolocation information collection. Restrictions on the user's ability to see how many likes they've received on content or other forms of feedback they might be getting through the system. Restrictions on the ability to message other users directly or engage in online chats. And then finally, restrictions on autoplay functionality, which is where you open the service and the video will start playing without having to press a button. The infinite scroll functionality, or the ability to watch live streams on the service. There also are very commonly specific restrictions on profiling and advertising on the service. So when it comes to targeted advertising, some of the laws will, impose additional restrictions on that. Something, a very common one, for example, is requiring consent of the minor or parental consent in order to use personal information to display targeted advertising to that younger user. Other laws focus on profiling rather than targeted advertising specifically, and impose similar restrictions on profiling activities. Some of the laws, when it comes to advertising, will include requirements that if you're going to have advertising, the advertising needs to be age appropriate. So obviously you wouldn't want to display ads for products that are unlawful for the minor to purchase or use, is an example of those types of restrictions. And then some of the laws get quite granular and say you can have ads, but those ads by default should be based only on the child's age and imprecise location information. So you see a lot of variety in terms of how the different laws kind of address advertising and profiling activities. These laws also have a number of other considerations that I wanted to spend a few minutes flagging. First, a lot of these laws will require risk assessments. And if you've been a privacy professional for a while, the idea of a privacy risk assessment is probably very familiar to you. However, it's worth noting that the risk assessments required under these minor protection laws, often the requirements look very different than your typical privacy risk assessment. They tend to be focused not so much on what information is collected and how it's processed and kind of the information handling practices, and instead will often require companies to document the different types of risks that the service potentially pose to the minor and the safeguards used to address those risks. And including things related to content and um, some of the well-being provisions that we talked about earlier. These laws also often have data minimization provisions, which requires that if you really should only collect information if you truly need it, and you should make sure that when you're processing that information, it's only being used for the specific purposes for which it was collected. Kind of related to the data minimization concept is the data retention limit requirements that we see in a number of these laws. So, for example, some of these laws will basically say you can only keep the information for a definite period of time that you need it in order to provide the purpose for which it was collected, after which you need to securely delete it. And then finally, and this one's probably not surprising to anyone, then a number of the laws impose data security requirements on how companies protect the security and confidentiality of the information that is collected from minors. So finally, I want to end by chatting about kind of what's coming next and kind of how to adapt to this very evolving landscape. So, what I've tried to do in the first part of the session is help you identify what are the triggers that will put you underneath or make you be regulated under these laws, and give you a general sense of what the key requirements are that regulators are focused on. But I really want to emphasize that although there are those common themes, there is a very, very wide range of different legal requirements, and it's a very rapidly evolving space. So you will have noticed a theme across the different slides that I presented today are that there's a lot of variety in the specific standards that the laws impose, the different thresholds that trigger these legal requirements. And unfortunately, I think that trend is going to continue. And so we'll talk a little bit more about how, in practice, how to manage that. So I've included on this slide 4 key things to watch for as this space unfolds. So first, we've seen a number of different court challenges in this space, kind of addressing a whole range of different types of laws that we've discussed so far. So, for example, there's been a number of court challenges that get at the issue of age verification online and concerns around whether or not age verification is in conflict with some of our constitutional principles or creates potentially heightened privacy risks. There's also been a number of court challenges related to the data protection or DPA requirement or impact assessment requirement. Um, as I mentioned, sometimes those laws focus on concerns around the content of information that's shared online or other issues that go beyond the typical privacy impact assessment. So a number of challenges have been brought related to those requirements. And then there's also some challenges that just get at, you know, a lot of these standards that we've talked about are very nuanced. They vary state by state, and there's not a lot of guidance necessarily in the laws that clarify what these different standards mean or how they'll be applied by regulators in practice. So we see some challenges around whether or not those standards are too vague and whether or not there needs to be more clarity in order to guide industry to allow them to be able to comply with these legal requirements. So it's, I think, as a practical matter, helpful to continue to monitor those court challenges, see how they unfold, and based on what is being upheld, what's being enjoined, kind of help guide you in figuring out where you should focus your scarce resources when it comes to coming into compliance with the requirements, and take a risk-based approach when building out your compliance programs. A second thing to watch is the federal COPPA rule amendments. So in 2019, the Federal Trade Commission announced that it would be revamping its COPPA rule, which is the only federal standard we have right now when it comes to minor protection. The COPPA statute, like I mentioned earlier, regulates the online collection, use, and disclosure of personal information from children under the age of 13. So when we're talking about the federal standard right now, we're really focusing on those under 13-year-olds. Right before the change of the administration in January, the Federal Trade Commission released an updated COPPA rule. However, the new chair of the Federal Trade Commission has indicated that some additional cleanup might be needed before that rule takes effect. And that rule states that it won't take effect for at least a year after it's published in the Federal Register notice. So there's a lot in flux in terms of what the federal standard will be moving forward. But it's interesting to kind of note some of the key changes to kind of see how the law is developing and is likely to continue to develop at the federal level in the future. So to point out a few key themes coming out of that new rule. One is that the Federal Trade Commission did accommodate a number of new mechanisms for obtaining verifiable parental consent in order to provide companies more flexibility. So one example of this is to allow parents to provide verifiable parental consent through text messages, as opposed to calling up a 1-800 number, returning a printed form, having a credit card charge, or other like more antiquated means of communication these days. Another kind of key takeaway from those COPPA rule amendments was related to data retention. So the COPPA rule that was enacted prohibits indefinite data retention and imposes a requirement to publish your data retention schedule publicly. And both of the current Republican commissioners have expressed some concerns with that restriction on indefinite data retention and indicated that that might need to be an area for some further clarification. One thing that is interesting from the FTC chair's separate statement to the COPPA rule amendments was related to age verification. He indicated that it could be helpful for companies to be able to collect um, government ID information, photos, videos, other types of information that could be used for age verification. So if you think back to the age assurance standards that we talked about earlier, it's interesting to kind of note that that's not something we're only seeing at the state level across the state laws, but also something that has come up in the separate statement in the context of the COPPA rule amendment. And then one of the final changes I wanted to flag with respect to the COPPA rule amendments is this concept of transparency. One of the more surprising changes that that I think came out of the COPPA rule update is the requirement to provide additional transparency about the third parties that companies disclose personal information to. And the final rule suggests that you might need to get separate verifiable parental consent to certain disclosures to third parties that are not integral to the operation of the service. And so it'll be interesting to watch whether or not there's any additional changes when it comes to those COPPA rule revisions. The third thing that's worth noting is the state rulemaking. So um, most of the state laws are just statutes. They don't have separate rulemaking authority, but there are a few that would allow state regulators to go beyond just the text of the statute to issue interpretive regulations that clarify how the statutory text will be interpreted and applied in practice. And so one of the state rulemakings that I think will be quite influential and is worth watching is the rulemaking that is ongoing in New York. As I mentioned before, that statute has one of the third party age signaling provisions. So, this concept that devices or browsers can signal the age of the user and has a explains what companies are supposed to do with that information when they receive it. Interestingly, last year, the California legislature passed a very similar provision that would have dealt with browser and device level age signals. However, that provision was part of a bill that was vetoed by the governor. So New York is really taking the lead when it comes to these age signal type requirements. And it'll be, I think, really important for companies to kind of watch how that unfolds, including whether or not there's any clarity on what companies should do when they get conflicting signal information. And then finally, the last thing I wanted to flag for companies to watch is federal legislation. So, there's been a lot of ink spilled on the possibility or likelihood of whether or not comprehensive federal privacy legislation is enacted. But separate from that conversation is another thing to watch, which is federal minor specific privacy legislation that is under active consideration. So there's three primary laws that are at play when it comes to kids and teens. One is commonly referred to as the COPPA 2.0 bill, which would amend the federal Children's Online Privacy Protection Act to kind of extend a number of COPPA's provisions and update some of the definitions and other requirements. A second bill is the Kids Online Safety Act, which is more similar to some of the online protection bills that we see at the state level. And then finally, there is a social media law, specific law that would be focused on whether or not young children can even access these services. So a number of the provisions, definitions, the scoping of those federal laws are different than the definitions, requirements, and scoping of the state laws that have been enacted and have started to take effect at the state level, and watching the interplay between the federal legislation, if it's enacted, and the state legislation that is already in effect will be, I think, really important for companies to monitor as they try to rationalize their minor protection programs. So, kind of with that background on the very evolving and influx kind of legal landscape, I wanted to leave you with some kind of key takeaways, some practical tips for how do you kind of manage this chaos that that we're faced with as an industry. So I think first and foremost, it's really important to figure out what specific laws apply to your business. As I mentioned, that's going to require very careful attention to those different types of triggers that we talked about at the beginning of the presentation. Um, they're kind of a layered onion approach. The definitions are not consistent across the different laws. So it really requires going through with a fine tooth comb to see, when they say one thing, is that the layperson understanding of that, or is the definition, which gets highly technical and has lots of exemptions, might you fall within the exemptions? Once you've figured out the universe of laws that apply to you, I think the next step is that's really helpful is to figure out what are the commonalities across the different laws that apply to you. You might find that the age appropriate design code are the type of laws that really impact your business if you don't have a lot of social functionality and you're more in the teen space than the under 13 space. And that'll kind of give you a sense of the types of requirements that are most likely to apply to you. And you'll be able to kind of quickly figure out that some of the other provisions like COPPA or the social media provisions are not really what you have to worry too much about. Then once you have a sense of the laws that are most relevant for your business, that's where I think the ongoing court challenges and where the laws are headed can help you figure out what are the different priorities that you should focus on and the order in which you should focus on them in. So, for example, I always put the first tier as what's already legally required across a number of different legal frameworks. So, for example, things like parental access, deletion, and consent might already be something you have to do under the federal COPPA statute or under the state comprehensive privacy laws. So if you're already doing that to comply with other legal requirements that are already in effect, those are easy wins, easy things to check off the to-do list. The second tier of things might be things that if you think about your service or your website from the perspective of what your customers would want, what consumer, like how you would build consumer trust, there might be things that are the right thing to do anyway, like looking at your privacy settings and your account controls to see if there are already things that you offer because customers demand it, or things that you've been wanting to do anyway. And this gives you the incentive to kind of take the next step and start implementing these new defaults, controls, different options for your customers. And then the third tier are the unknowns, the things that are not yet in effect, are subject to challenge. There isn't currently any technical solution on the market that would allow you to comply, like age signals, where there's just still it'd be kind of wasted effort for you to take steps at this particular moment in time that might push you too far down the road before we get guidance from regulators kind of clarifying what some of these things mean. So if you look at your roadmap and you kind of bucket the to-do list in those three categories, that should help provide you a pretty good risk-based approach to building out your minor compliance programs in the United States. And with that, I will pause and see if there's any questions.
So, Lindsey, not seeing any questions on this side.
Great.
So I wanted to thank you. It always amazes me how much this changes and how many new things pop up every year in this field. So incredibly difficult for anybody to keep up with. So I appreciate you taking time to share with our audience at least an overview of what they should be looking for or questions they should be asking if they're not deeply versed in this themselves.
Okay,
So thank
happy
you.
to do it.